supposed to construe those exceptions narrowly. Can you cite some cases where a tribe has had jurisdiction over a non-member under those exceptions?
Well, Your Honor, I will cite some cases that explain the general rule. And it started.
No, I'm not asking for the general rule. I'm asking for cases where they have applied the exceptions for jurisdiction over a non-member.
For one, United States versus Marion by United States Supreme Court. Second, in the Ninth Circuit in Means, which is very much like Strait. In that case, they had a tribal road, a BIA-owned road. Because it was not an easement and conveyed to the state like Strait, it still belonged to the tribe. Although it was still the BIA, it still belonged to the tribe. They did not go to the presumption of no jurisdiction. They did not go into the exceptions. They follow the presumption of jurisdiction in that case. Your Honor, I will. Yes, Your Honor.
You're comparing the facts of Marion to the facts of this case.
Well, Your Honor, in that case, it was actually a non-Indian who they asserted jurisdiction over, and the court granted that jurisdiction. But more specifically, Means is more directly like this case. The facts are closer to this case. And Your Honor, in Iowa Mutual, the court, and I quote, stated that.
But what if we agree with appellant's argument that this occurred in a parking lot, and so therefore is a right-of-way similar to what we had Strait?
Well, Your Honor, they turned to the 5 points in Strait that created that easement, that they found that the easement was like an alienated land in Montana versus United States, and therefore the tribe did not have a presumption of jurisdiction. Number one, the lack of exercising gatekeeping rights. It was important in that case because a highway crossed state and tribal borders. This parking lot is fully within the tribe's borders. Number two, a lack of consent. In this case, we have an intertribal agreement. Mr. Manigdewald, through his tribe, agreed and consented to be held to any orders that the Rabbit River tribe issued. Number four.
Okay,
yes, Your Honor.
Ladies first.
He consented? Where in the facts did he consent?
The intertribal agreement, Your Honor.
Okay, well, there may be an intertribal agreement, but if the Rabbit River tribe does not have jurisdiction, you can't enforce lack of jurisdiction through an intertribal agreement. Won't you agree with that?
Yes, Your Honor. And that is why we're asking this court to determine if the tribe has civil jurisdiction in this case, and we assert that they do under one of two theories. Now, Your Honor, to conclude with the Strait analysis, number four, compensation. There's nothing on the record that cites any compensation in this case for the casino. Number five, this is not a right-of-way. It's not crossing state and tribal borders. And finally, there's no conveyance of the property, of the parking lot to a third party. In Strait, it was conveyed, the easement was conveyed like any property to a state. Now, moving on to some reinforcements to the presumption of tribal jurisdiction. There are 3 points to reinforce that a presumption exists in this case. Number one is the intertribal agreement. Number two is his status as a federally recognized Indian. And number three is a policy of tribal self-determination. Now, turning to the intertribal agreement, in Plains versus Commerce, in explaining Montana versus United States, the court stated that there was an underlying concern in Montana that the non-member in that case wasn't involved in the political process of making those laws. But in this case, there's an intertribal agreement. Mr. Manigdewald has a say in his tribe's intertribal agreement. And this agreement states that any orders coming out of the Rabbit River tribe will be enforced. So in this case, a consent.
But any kind of comity is sort of premised on the fact that the issuing court actually has jurisdiction. I think that there's no rule that in an intertribal agreement or state-state agreement that you're going to enforce orders that don't have jurisdiction.
Right, Your Honor. And his tribe, Mr. Manigdewald's tribe, has the power to not enforce it if they believe due process or any other fundamental right is not followed. And they have not. They have not intervened in this case, and they have on their own.
Maybe they should.
Sure?
Maybe they should.
That is their prerogative, but they haven't, Your Honor. In this case, they have not.
Would the result that you're asking the court to reach be different if there was no intertribal agreement? Or it would still be the same result?
It would be the same result, Your Honor, but if this court questions the presumption of jurisdiction, these facts only reinforce that presumption. Now, Your Honors, if you still disagree with the presumption of jurisdiction and believe that the shift was made, and in this case there is a presumption of no jurisdiction, my co-counsel, Mr. Copper, will address the Montana exceptions, and under one, if not both of those exceptions, the Rabbit River Tribe still has civil jurisdiction. Thank you.
Good afternoon. May it please the Court. Maxwell Copper for Appellees, the Rabbit River Tribe. In response to Mr. Monty DeWog's arguments, I will be presenting two separate points of analysis. First, even if the Court were to disagree with the arguments of co-counsel and hold that the Montana presumption of no jurisdiction applies in this case, the Rabbit River Tribe still had civil jurisdiction over Mr. Monty DeWog under one, if not both, of the Montana exceptions. Second, the question of whether the civil contempt or forfeiture actions were civil versus criminal is a moot point because the Rabbit River Tribe had both civil and criminal jurisdiction over Mr. Monty DeWog. Before moving to the individual Montana exceptions, an analysis of the land status in this case is appropriate. Even if the status of this land as tribally owned does not create a presumption of jurisdiction, as co-counsel has argued, it still remains an important factor in the Montana analysis. Justice O'Connor, in her 2001 concurring opinion in Hicks, while not governing, is persuasive in this case. She states that the Montana exceptions are far more likely to be implicated where the non-member activity occurs on land owned and controlled by the tribe. The reasoning for this is simply that when the activity occurs on tribally owned lands, the tribe has a second power in addition to its sovereign powers.
But that was a concurring decision, right? Do you have any actual plurality or majority decision that concurs with Justice O'Connor?
Not at this time, Your Honor, but we ask the Court to recognize the significance of this hold.
A one-judge concurring opinion is significant enough to have us extend Montana to the situations at issue here?
Well, Your Honor, there are also authority under the 8th and 9th Circuit, which...
There's also authority under two other circuits going the opposite way, and it's very persuasive authority, I would say.
What authority is that, Your Honor?
I think
Ninth Circuit?
you usually don't ask the bench questions.
Well, I believe we are referring to the same cases in attorneys processing and Babbitt Ford. Those cases actually establish a lesser standard for meeting the Montana exceptions when the activity occurs on tribally owned land. And the reasoning for this is because there are two powers, instead of just the tribe's inherent sovereign powers. When the activity occurs on tribally owned lands, the tribe then has the power of a landowner and the right to exclude.
In those cases that you would cite us to, what was the political status of the individual at issue?
In both those cases,
Yes.
they were both non-members and non-Indians.
Not Indians, so non-Indians.
Non-Indians, yes. Specifically, when we also look at the reasoning behind the Montana analysis, a tribe's sovereign power has been limited, yes, to its ability to control self-government and control internal relations. The definition of what constitutes an internal relation is much broader when that activity occurs on tribally owned land.
But here all we have is a scuffle between a member and a non-member. Why does that implicate the tribe?
Well, Your Honor, specifically under the first Montana exception, and then I'll move on and address your question under the second Montana exception. But
I think you should address the question now. How does this apply? How does the tribe have a concern?
Under the first Montana exception, a tribe may regulate the activity of a non-member who enters into a consensual relationship with the tribe, and this...
Well, how did they enter into a consensual relationship with the tribe for this issue?
For this issue, Your Honor, the consensual relationship was formed by Mr. Monty DeWog entering into the casino and entering into a gambling business relationship in that sense.
What's the nexus between going to a casino to gamble and the activity that your tribe is seeking, or that your client, the tribe, is seeking to remedy here through the civil citations?
Well, Your Honor, under Atkinson, the nexus requirement means that the activity, or that the activity being regulated must arise out of the consensual relationship. Specifically here, the activity being regulated, namely the flight and the bringing onto tribal grounds of the marijuana and the unregistered loaded handgun, arose out of Mr. Monty DeWald's activities of his intent